Wonderful. Thank you so much, Wes, for that delightful introduction. Good morning, good afternoon, everyone. I'm really pleased to be here. I've really enjoyed this series. It's incredibly timely, particularly given that there's no question that the incoming Biden-Harris administration is really promising to recenter the protection of civilians in their overseas military operations. And so the series has been fantastic, and I'm quite honored to be a part of it. So I've been asked today to kick off our discussion around accountability for harm to civilians. The norms in question, including prohibitions on the range of war crimes and other breaches of IHL, can be litigated in a number of fora, international fora, regional fora, and domestic courts, etc. And so I thought I'd sort of sketch out the architecture of accountability, focusing on courts, but then I will be identifying a number of places where non-court institutions, such as investigative mechanisms, commissions of inquiry, et cetera, might also play a part here in providing some measure of accountability for breaches of IHL involving civilian entities. And I'll be focusing on not only criminal cases, but also civil claims by victims and survivors against responsible individuals, legal entities, and sovereigns. So maybe, Jimmy, if you could throw the slide up quickly. I'm just putting a little chart here on the screen, which is how I think about the global architecture of international justice. When I'm addressing a client or teaching, I try and think about the various options that are available to survivors, victims, et cetera, in order to press claims involving any violation of international law, including human rights, laws of war, et cetera. The matrix is organized, as you'll see, along two axes. The x-axis is really premised on the type of tribunal, focused on international tribunals. Now we have a set of regional and hybrid tribunals, and then domestic tribunals to the far right. And then the y-axis really compares the identity of the respondent/defendant. And so thinking about individual natural persons and legal persons on the one hand, and then sovereign entities on the other. And then because I'm not smart enough to figure out how to do this in 3 dimensions, I had to use colors to designate criminal claims that would be brought against an individual by a sovereign entity or by the international community through some sort of an international institution, or civil claims that would be brought by the survivor victim themselves. And so those are delineated by colors there. So Jimmy, thanks. I think we can take that down, and I'll just refer to the various cells in that matrix as I go along. And I thought I'd use the example of Syria, drawing from a book I've recently published called Imagining Justice for Syria, in which I have a chapter on each of these potential accountability mechanisms. It's been characterized by industrial grade war crimes, very much focused on the civilian population, and an almost impenetrable impunity. But there are some cracks in this impunity, and so I'll highlight those as I go along, discussing each of the cells in that particular matrix to illustrate the various accountability options that are available. So starting with the top left corner of that chart, with international institutions exercising individual criminal responsibility, early in the conflict, it was clear that events in Syria would easily surpass the gravity threshold of the International Criminal Court. However, Syria is not a party to the Rome Statute, and so the ICC cannot have plenary jurisdiction over events there, absent either a referral by the Security Council or a subsequent ratification by Syria, which it could do, for example, in the event of a political transition, and it could backdate jurisdiction using an ad hoc declaration under Article 12.3 of the ICC statute. Neither of these has come to pass, particularly given that Russia has vetoed a French-led effort in 2014 to refer the matter to the court. Now, there are some creative theories as to how the ICC could exercise some jurisdiction over a subset of crimes committed in Syria, and this has been playing out in other situation countries as well. So first, there are crimes that are committed by the nationals of ICC states parties, and this would include so-called foreign fighters who, motivated by ideology, religion, kinship, and even love in some cases, have flocked to the region to join the fight. The second subset might be crimes committed on the territory of other ICC member states, both near and far, with some kind of a nexus to the Syrian conflict. So for example, crimes having an impact on neighboring Jordan, borrowing from the Bangladesh-Myanmar situation in the ICC, attacks on civilians committed by members of ISIL in Europe, for example, but orchestrated by leadership in the region, in Syria. Or third would be crimes committed on the territory of other states that are already before the ICC, such as Libya, by individuals also active in Syria, such as ISIL leadership. So far, however, the prosecutor has declined to move forward under any of these tracks, indicating, at least for now, that the jurisdictional basis for proceeding with what's called a preliminary examination is too narrow at this stage. And so the focus really is on more comprehensive accountability, but also being able to reach the leaders of and leadership crimes, architects of war crimes. Finally, I should just flag that there are some theories floating around about how the Security Council could potentially refer the situation involving ISIL to the ICC. This could encompass the organization itself, untethered from any territorial space, or the transboundary statelet that once encompassed ISIL's imagined caliphate. So far, however, the political will has not existed for that to happen, and so movement at the ICC has been unavailing. It was originally hoped that the establishment of the ICC would obviate the need to create other ad hoc institutions. This presumption, however, has really proven to be misguided. It's increasingly recognized that the ICC just simply can't handle all of the atrocity situations that are ravaging our planet, either because of jurisdictional gaps, the unwillingness of the Security Council to act, or even just basic resource constraints. And so given the duration, complexity, scale, and nature of the Syrian conflict, there's no way the ICC could provide a comprehensive accountability. And so the possibility remains that an ad hoc court dedicated to Syria could work in tandem with domestic courts on the one end, but also potentially an exemplary case that might in the future end up going forward before the ICC. So there are a number of mechanisms available to establish such an ad hoc court, even without Security Council approval or the consent of Syria. These have been batted about the international community, but none of these proposals so far has garnered sufficient political will to really move forward into the sort of design and building phase. But one option would be for a subset of impacted states relying on the effects jurisdiction coupled with universal jurisdiction to pool their jurisdictional competencies and to create a new standalone international institution. This would be akin to the Nuremberg Tribunal after World War II, for example. You could also imagine states joining a sort of a proto-ICC focused solely on Syria that would be exercising a form of universal jurisdiction over events in Syria, given that the war crimes that we're interested in, including crimes against humanity and genocide, are all subject to universal jurisdiction under international law. And so an international institution could exercise this pooled jurisdiction. And an interesting precedent are the extraordinary African chambers that tried Hissen Habre, which was essentially an international tribunal exercising universal jurisdiction focused on a particular situation country. Moving across the matrix, if you recall, the middle panel dealt with regional and hybrid institutions. Theoretically, the League of Arab States could create a regional tribunal similar to the one being contemplated by the African Union. Any of these international institutions that I've been discussing could be hybridized with various Syrian elements, including reference to Syrian law, Syrian jurists being integrated into the staffing at all the various organs of this particular tribunal, etc. None of these proposals, unfortunately, has moved forward, but they're still, my understanding is still being debated, particularly given the real threat posed by foreign fighters and the unwillingness of states in Europe to take back their nationals. And so there's a keen interest in finding an international solution to the problem of accountability there. Now, if we move across the matrix, the next column was pure domestic courts. Ideally, these cases would be brought in the domestic courts of the impacted country itself. The proximity to the events in question, et cetera, increases not only the sort of practical concerns about bringing justice, but also just the expressive function of international justice. Also facilitates access to evidence, more engagement with survivors, witnesses, et cetera. Now, focusing on Syria in particular, multiple legal systems have operated in Syria over the course of the conflict, in government-controlled areas and opposition redoubts, in territory under ISIL control, and in parts of northern Syria under Kurdish control. Syrian courts, however, have not really emerged as engines of accountability. And in fact, the formal Syrian courts, the courts of the regime, have really been deployed as tools of oppression against members of the opposition. And there's a real misuse of counterterrorism legislation and authorities there. Even if these were functional, however, the Syrian Penal Code and even the military penal code do not include a robust articulation of war crimes or other international crimes. Now, of course, any of these crimes could be prosecuted as ordinary crimes of murder, mayhem, assault, etc., under Syrian law, but the political will is not there to have a broad-based accountability program. The Kurdish-led autonomous administration in northeast Syria is another story. They could, and there seems to have been done, convening tribunals in order to prosecute certain war crimes, including crimes against civilians, particularly given the unwillingness of states to take back foreign fighters. Of course, this raises a number of questions about the legal legitimacy of non-state actors convening and conducting war crimes trials, but also practical questions about the ability to hold these trials under applicable international human rights due process standards. Now, while IHL does not affirmatively authorize or definitively prohibit non-state actors from convening such judicial proceedings, it actually seems to contemplate them, given the formulation of Common Article 3, which talks about the prohibition on the passing of sentences or carrying out of executions without a previous judgment by a regularly constituted court, affording all of the necessary judicial guarantees. The substantive law could be pre-existing Syrian law, notwithstanding all of the limitations to it, or potentially international law, so long as it's consistent with the nullum crimen sine lege principle of legality. Now, when courts in the affected country are foreclosed, as they are in Syria, legal processes in courts in other countries offer an advantageous second best alternative. When it comes to events in Syria, European and some regional domestic courts are emerging as more fertile grounds for justice. There are a number of domestic trials underway in Koblenz and elsewhere that we've been able to follow in the news, featuring a range of criminal charges and fact patterns. These fall into two general buckets. You have cases that are invoking counterterrorism authorities focused on foreign fighters joining a designated foreign terrorist organization, etc., often against foreign fighters who have returned to the comforts of Europe. States are generally highly motivated to prosecute these cases under a national security kind of framework. The second subset of cases are really war crimes cases in the strict sense. These are facilitated by the incorporation of international criminal law into domestic penal codes, including through ratification of the ICC statute. There's also a number of war crimes units around Europe that are increasingly interlinked, sharing information. There's an interoperability that's happening between these various institutions, and also domestic accountability documentation centers, either operating in Syria or operating outside of Syria, with sending investigators into Syria to bring evidence out. So that's the gamut when it comes to criminal accountability. I'm going to switch now into civil trials, because the second row of our accountability matrix is focused on these civil actions. There's no international, regional, or hybrid forum that allows for civil claims to be advanced against individual perpetrators. As such, these cases must be brought in domestic courts. This is very well developed in the United States under the Alien Tort Statute, the Torture Victim Protection Act, etc., that allow for federal courts to assert jurisdiction over torts in violation of the laws of nations. This movement was kicked off by the famous Falartiga case and has been moving forward ever since. The Supreme Court has significantly truncated the reach of the Alien Tort Statute, particularly as it comes to foreign conduct and foreign corporations. There's a case now pending, the Nestle case, which involves domestic corporations accused of committing forced child labor in the chocolate industry. And so it remains to be seen whether the court will continue to amend the statute through its jurisdiction. At the moment, even as they stand, there are no civil cases pending in the United States involving Syria for lack of personal jurisdiction over any responsible defendants. Syrian perpetrators have simply not traveled to the United States, in part because of severe immigration limitations that were put in place by the Trump administration. Not so in Europe, and so many victims are able to piggyback off of the European criminal trials in order to press civil claims against the particular defendants. So these civil cases exhaust the top half of the matrix. I'm going to now shift to ideas about state responsibility and holding sovereigns responsible for breaches of IHL, including harm to civilians. The next row of the matrix was completely empty because there is no notion of criminal responsibility for states. This was contemplated when the International Law Commission was drafting its articles on state responsibility, but there were a number of concerns that arose, particularly just how do you think about mens rea, et cetera, when it comes to sovereign entities. And so ultimately drafters decided not to include a concept of state criminality per se within those articles. And so we're really stuck with domestic courts or the International Court of Justice in terms of dealing with state responsibility. The ICJ, as we know, can hear claims against states that are of a civil nature, only those states, though, that have accepted its jurisdiction. Now, several international criminal law treaties do grant the ICC jurisdiction over states' parties. For example, Article 9 of the Genocide Convention speaks of disputes over the interpretation, application, or fulfillment of the present convention, and this has been interpreted to include allegations of state responsibility for genocide. Likewise, though, there are a number of so-called friendship, commerce, and navigation treaties, et cetera, that might also enable jurisdiction over states to bring war crimes type claims. So we saw this in the Nicaragua against United States case, which dealt with allegations of the unlawful use of force by the United States. But you could also imagine similar claims being pressed under IHL involving potential war crimes. We've also seen arbitral tribunals in the arbitration, for example, between Eritrea and Ethiopia over potential war crimes committed in the context of the bilateral war between those two states. Now, it was once rare for states to bring claims against each other before the ICJ in a kind of human rights / IHL context. It hasn't historically been a forum for that. But we've seen that changing in recent years. We have the genocide case that Bosnia brought against Serbia and Montenegro, most recently the Gambia with the backing of the Organization of Islamic Cooperation, filing an application against Myanmar under the Genocide Convention. Also before the ICJ, Myanmar is now subject to provisional measures under the treaty and with the backing of the ICJ. Turning to Syria, the Netherlands has recently invoked the Torture Convention and has told Syria that is planning to institute a case against it under the ICJ. It's now in a mandatory sort of mediation arbitration phase, and so remains to be seen whether Syria will accept the invitation to engage in arbitration over these allegations. Presumably it will not, and so that case too would go forward before the ICJ in The Hague. Now, the ICJ only has jurisdiction between states, so individuals have no direct standing to advance claims against responsible states. By contrast, there are a number of human rights institutions, either created by treaty or as part of the UN system, that can receive complaints against states by individuals if the state in question has accepted such jurisdiction. And these human rights bodies have varying powers of enforcement and thus effectiveness. Now, while their subject matter jurisdiction really relates to human rights, there are points of overlap, as we know, with IHL, particularly when it comes to civilian harm. And so these bodies have waded into IHL waters, much, I should say, to the chagrin of some states, such as the United States, which often insist that opining on potential war crimes falls outside of the institutional competencies of these institutions because they're empowered to look at international human rights law, and IHL is really the lex specialis under these circumstances. Nonetheless, there have been a number of cases in which human rights bodies, including regional courts in the inter-American system, have adjudicated claims that would essentially be equivalent to war crimes committed against civilians, including civilian casualties. Now, returning to our Syrian case study and really highlighting and bringing into stark relief the limitations of these institutions, all of them are basically unavailing against Syria because it has not consented to or has opted out of all of these various mechanisms. The final cell in our matrix is domestic trials. Now, as we know, domestic courts have only limited jurisdiction over sovereign states for breaches of international law due to the principle of foreign sovereign immunity. The United States, however, and some states are starting to follow suit, has enacted a form of conditional sovereign immunity and has slowly built in a series of exceptions to this blanket protection of immunity that states enjoyed historically. And so in 2008, the Congress has withheld sovereign immunity for designated state sponsors of terrorism for certain violations of international law. Syria has been designated as a state sponsor of terrorism for many years, dating back to its early days mucking around in the region and in Lebanon. And so a number of suits have been brought against the sovereign state of Syria. One in particular that I should highlight was brought on behalf of the Center for Justice and Accountability, on behalf of the family member of the famed war correspondent Marie Colvin, who won a $300 million judgment against the state of Syria for assassinating Colvin while she was covering the war in Syria. Now, this is on the one hand a very good news story, but on the other hand, it's a single case involving a US victim, and it's really left the victims of other abuses within Syria unable to access US courts because the Foreign Sovereign Immunity Act only applies for when there are US victims or the family members are US citizens. So with that tour of the horizon, when it comes to the enforcement of IHL, there's really a high degree of jurisdictional concurrence between international, regional, and domestic institutions and between criminal and civil processes. And this typology of culpability with its two axes, individual versus state responsibility, tort versus criminal liability, illustrates that liability can exist concurrently in a number of different fora. So far, the enforcement of IHL has been so scattered and exceptional that there hasn't been a lot of overlap where multiple courts are looking at the same sort of crime base. The case against Serbian defendants before the ICTY, and then also the case before the ICJ, and then the ICC's work in Burma, Myanmar, and Bangladesh, and then the Gambia suit against Myanmar and the ICJ are sort of notable exceptions where you have international courts looking at the same body of evidence at the same time. But the potential does exist for potentially divergent outcomes and the fragmentation of law, et cetera. But what we've actually seen now is a high degree of cross-fertilization between these institutions. They're reading each other's jurisprudence, they're citing it as authoritative, they may be departing from it, but it's clearly part of a much more robust and integrated system of accountability for violations of international law generally, and also IHL violations against civilians. So I think I'll end there. I'm really pleased to hand this back over to Jeff Korn. Looking forward to hearing from the rest of the panelists as this discussion continues today. And thanks again so much for all the organizers of this really terrific series. It's been an incredible benefit. And if anyone has missed the earlier sessions, they're all available at the Liber Society's website on ASOL. And so I encourage you to go back and look at the earlier sessions. So thanks very much.
Thank you, Beth, for that outstanding overview and setting the conditions for our discussion, because we have three outstanding experts who I think are going to take us from the broad down to the more specific by focusing on the role of universal jurisdiction in enhancing accountability for abuse of civilians during armed conflicts, and then the role of international tribunals in enhancing accountability. And then Colonel John Cherry will wrap it up by giving some insight into how a military like the United States actually tries to implement its obligations to enhance accountability. My name is Jeff Korn. I'm a professor at South Texas College of Law in Houston, and I'm delighted to be able to moderate this panel, but the real expertise is going to come from our participants. I will introduce each of them individually as they present about a 10-minute overview of their thoughts on this topic. We're going to start with Olympia Beku, who's going to address the relationship between universal jurisdiction and accountability. Olympia is a professor of public international law and head of the School of Law at the University of Nottingham. She's a qualified lawyer and specializes in international criminal law. She's undertaken numerous capacity building missions, including in post-conflict situations such as in Colombia, the DRC, Liberia, Sierra Leone, and Uganda. She's provided legislation, drafting assistance to Samoa with the legislation enacted in November of 2007, and Jamaica, and has been involved in training the Thai judiciary. In 2014, she was awarded the University of Nottingham Knowledge Exchange and Innovation Award for societal impact in social sciences for her work. And in 2015 through 2016, she was recognized as an impact leader as part of ESRC's Impact Leaders Program. Marie-Helene will address the role of international criminal tribunals, accountability, and universal jurisdiction. Olympia, it's up. I'm sorry, I confused that. Olympia, I turn it over to you.
Thank you, Jeff, and thank you all for being here. It is a real pleasure for me to join you today on this panel. And thanks to Beth for this amazing introduction, which has made my job very easy because it flows on from what she was talking on already, but also difficult because she's touched upon some of the things I wanted to present. So in my presentation, I'm going to focus on the role of universal jurisdiction and what role this universal jurisdiction could play in addressing crimes involving mass civilian casualties. Let me begin by emphasizing that I do not see universal jurisdiction as solving the problem of accountability for mass civilian casualties. I wish that were the case. I do see it, however, as an important tool in filling a gap with regard to accountability, particularly where other mechanisms are not present. I would argue that where mass civilian casualties exist, there may be reluctance or a somewhat lackluster response to own responsibility. Beth has already referred to the pooling of jurisdiction being discussed for Syria as a way forward for the atrocities committed there. So what role can universal jurisdiction play in those situations? My argument is that universal jurisdiction has a role to play when countries are reluctant to try their own people or there are no other courts or tribunals in place. So how do we bring justice when victims can't routinely access it? Let me first look at the prospects. Obviously, questions of jurisdiction are at the heart of this discussion. Whilst undeniably territorial jurisdiction offers some distinct advantages in terms of ease of access to evidence, deterrence, reconciliation, and victim participation, it is not always possible to process individuals within the courts of national states, particularly in the countries where the crimes have been committed. So recourse is therefore to be had in other heads of jurisdiction, such as universal jurisdiction or jurisdiction based on presence of the perpetrator or of which the victim is a national. At its inception, as you would all know, universal jurisdiction was reserved for piracy or slave trading. But it is the heinous nature of the crimes that warrant the exercise of universal jurisdiction for core international crimes. Whilst the exercise of pure universal jurisdiction, that is jurisdiction without any link to the forum, is somewhat rare today, establishing jurisdiction based on presence or indeed residency, which is even stronger link, is key. And in fact, despite good intentions, it is not easy to exercise jurisdiction in an effective manner unless the accused is or has been present. We have seen doors closing in terms of universal jurisdiction in recent years. In practice, national systems are rarely agile enough or quick enough to act when a suspected criminal is simply passing through the territory, nor do they have the necessary resources allocated to universal jurisdiction, and they end up losing valuable opportunities for justice. In reality, this avenue is rarely direct. So what are the challenges with regard to exercising universal jurisdiction for mass civilian casualties? The first challenge I'd like to draw your attention to is that of framing the charges. What I mean by that is that it might not always be possible to frame the charges in a way that best reflects the crimes that have allegedly been committed. Beth already referred to that in her presentation. We have seen recent cases where the charges have been framed as terrorism or even immigration charges, for example, in some of the Liberian cases I'm very familiar with. I do therefore wonder, is this straitjacket effect that is using other instruments that do not cover core international crimes directly to exercise universal jurisdiction extraterritorially? Is it appropriate? And secondly, is it desirable? Ultimately, does it matter what the charges are? Or does it suffice that justice is done, albeit on a lesser or different charges? Should we bring core international crimes through cumulative charging, even though the original case involves different charges. We, international criminal lawyers, are programmed to talk about the stigma attached to international crimes as opposed to ordinary domestic law crimes. And we do actively encourage the correct characterization of charges. I'm guilty of that myself in my work on promoting the adoption of legislation incorporating the Rome Statute into national laws. I do see the point about terrorism being a crime against state security and not individuals, that the 2020 Trial Universal Jurisdiction Annual Review makes very convincingly. I do share their concerns about the impact on victim participation in particular. A related issue to this is obviously sentencing. Determining an appropriate sentence would not necessarily reflect the overall seriousness of the acts as they would pertain to other offenses, for example, to terrorism or immigration, as I mentioned. So how do core crimes fit in such processes? Should they be considered in tandem for the purpose of sentencing, or should they not? There is very little guidance on how much weight to give to crimes committed in a home state, or how to reconcile terrorism or immigration offenses, for instance, with conviction with underlying wartime acts. I would argue that the discretion that the court has in pronouncing a sentence would be a key aspect of this process. Another issue has to do with the temporal application of legislation. For example, the UK War Crimes Act or the ICC Act would have been more suitable for the alleged crimes of Agnes Taylor, for instance. However, the principle of non-retroactivity did not allow the charges to be brought under these pieces of legislation, but the Torture Act had to be used instead. So in fact, although jurisdiction extends to 1991 in the UK, still this is outside the time frame for the crimes with which Agnes Taylor was charged. Moreover, issues of due process may arise when dealing with trials extraterritorially. Not every extraterritorial expansion of law's application scope is acceptable, I would say. Fourth, extraterritorial trials do not operate in a vacuum. Although the integrity of the process before the forum where it takes place needs to be respected, the political ramifications of such trials cannot be ignored, as are practical challenges arising out of the need for interpretation, for instance, that normally wouldn't arise in a domestic case. I'm thinking here in particular of the 2016 Kumar Lama case in the UK, which collapsed because of very bad translation during trial. Collection of evidence to assist the trial is crucial for its success. It is not easy for national authorities exercising jurisdiction extraterritorially to collect such evidence in post-conflict states. National investigators would have to travel to the territory where the crimes have been committed, and in fact, even other states in which evidence exists, and they need to speak to victims and witnesses. Obviously, you don't have the authority of an international court here, so this could only happen through a commission rogatoire, which is basically, there is no guarantee that the national authorities of the state in question would allow or would accept such request. So it is not often an option for foreign authorities to collect evidence in such extraterritorial cases. Of course, use of new technologies such as video link may help in that respect, and I think the pandemic has allowed us to do that a lot more. But in practice, this is often not as easy to arrange. So evidence collection also requires certain experience and expertise that many national authorities understandably lack. So in practice, this means that in much of the evidence that we use in universal jurisdiction cases may come from sources either outside the country where the crime was committed or would have been provided by NGOs. So linked to that is the lack of paper trail often associated in many of such conflicts, which puts additional pressures. My argument is documenting atrocities in a comprehensive and systematic manner is therefore crucial for the success of any trial, irrespective of the forum which the trial is going to take place. Linked to that is the numerous issues that may arise with regard to witnesses. Many of the witnesses who testify in universal jurisdiction cases had never left their village before, never had a passport, never traveled on a plane, never appeared before a court, let alone a white person's court, nor would they be entitled to any form of protection when they return to their countries. Witness relocation is a huge issue, and it doesn't normally happen with regard to cases going on before national courts, or if it does happen, it happens exceptionally. So the final challenge I want to mention is that of cooperation. I have already alluded to it when I talked about evidence collection. Much of the success of trials before national courts will depend on state cooperation. Mutual legal assistance requests are not always met with enthusiasm and allow for considerable discretion in their execution. We cannot assume that cooperation will always be forthcoming in extraterritorial cases. To conclude, trials outside the country where the crimes occurred come with a number of expectations and challenges. I'm not arguing that they should not take place, far from it. However, I cannot disregard that doing justice remotely might just be too far removed for both the victims, as the message of proceedings taking place abroad may not reach them easily, but also for the truth, which is necessary and perhaps differently sought for before a national court, as well as the public appetite of the host country. In practice, many victims will not be in the courtroom or may not see justice being done, e.g. when the courtroom is in the US and the victims are in Afghanistan, Liberia, Syria, etc. My final word is on outreach. Outreach has been a massive challenge for all international criminal courts and tribunals. A national court prosecuting crimes committed abroad does not have such a mandate, or indeed interest and budget. Getting the message across to those it concerns is and will be problematic. On the truth front, truth is relative to the evidence at hand. A single national trial is likely to focus on a broader, contextualized, or indeed publicized truth. Finally, from my limited experience of following the UK cases in person, the public galleries are empty and the jurors, where present, are totally disconnected from the narrative. The average Joe's experience is far removed from understanding or indeed caring about international crimes. That said, extraterritorial cases remain, in some instances, the only avenue for doing justice, and I am all for them, particularly when they involve mass civilian casualties. Thank you.
Thank you, Olympia. You raised some issues that our next speaker is obviously going to be very familiar with, related to witness production and protecting victims and so forth. Marie-Helene Prue is an international criminal law expert admitted to the Quebec Bar in Canada since 2003. She holds a law degree from the University of Montreal and an LLM in international humanitarian law from the Geneva Academy of International Humanitarian Law and Human Rights. Marie-Helene is currently a defense legal consultant at the International Criminal Court. She was previously counsel at the Office of Public Counsel for the Defense. Prior to working in the defense bar, Marie-Helene worked as a legal officer with the Appeals Division of the Office of the Prosecutor and the Appeals Chamber of the International Criminal Tribunal for the former Yugoslavia, as well as in the ICC pretrial and trial chambers. She also worked as a legal advisor for the International Committee of the Red Cross and was a teaching assistant in public international law and international criminal law at the University of Geneva. Marie-Helene, the floor is yours.
Thank you very much, Professor Corrin, for the introduction. And thank you so much to the organizers for inviting me to the symposium, which has been really fascinating. First of all, I have to say that I wholeheartedly agree with Olympia's presentation, and a lot of the problems that she highlighted in her presentation are equally applicable to international tribunals. So accountability for civilian casualties is, of course, one of the raison d'etre of international tribunals, and the international jurisprudence is ripe with examples of it being put in practice, only if only for a very few selected perpetrators. But it faces significant challenges and limitations. And as Olympia said, this either will not be sufficient to solve the issue of accountability. Obviously, as Beth mentioned earlier, jurisdiction is one of the very first conditions for international tribunals to intervene in any given situation. Now, this didn't pose so many problems in the cases of the ICTY, ICTR, Special Court for Sierra Leone, for example, who all had very limited and defined jurisdictional mandate. And so these questions were evacuated pretty rapidly by these tribunals. In the case of the ICC, however, this can be a lot more controversial. I would only, for example, mention the issue of the Bangladesh-Myanmar situation, where the court has agreed to open an investigation, agreed for the prosecutor to open an investigation, for crimes committed, well, it's not clear, partly in Myanmar, but only through forcible displacement, which ended on the territory of Bangladesh, which is a state party, which of course Myanmar is not. So it'll be interesting to see what kind of accountability you can actually achieve just with a very small subset of victims. And also, it's also very controversial, of course, with the Afghanistan situation. Now, the prosecutor of the ICC requested permission to initiate an investigation into the alleged crimes committed in Afghanistan pursuant to Article 15 of the Rome Statute, based on strictly territorial jurisdiction, since Afghanistan has ratified the Rome Statute, and it entered into force on its territory in May 2003. But of course, the investigation that the OTP wants to lead would target perpetrators from all sides that have been active on the ground since that time, including the United States, and would encompass as many as 200 alleged incidents constituting war crimes and crimes against humanity, which is why this is becoming such a controversial issue. The motion of the OTP was filed in November 2017, and it took a year and a half for the pre-trial chamber to issue a decision, initially rejecting the opening of the investigation based on the fact that, according to the judges, it was not in the interest of justice to do so. Now, this decision was famously overturned last March by the appeals chamber. The motion by the OTP included many, many incidents which are described in a level of details in the motion. Of course, not very detailed since the investigation has not started yet. So they could only put what they had from open source and easily gatherable evidence. But interestingly, the 2015 bombing of the MSF clinic in Kunduz is one of the incidents listed in the prosecution motion to open an investigation. There's only one paragraph in the whole motion about this incident. And it concludes that there is simply not enough evidence to determine whether there is a reasonable basis to believe that the attack was intentional. So you can already see that this finding is very similar to the report led by the investigation on these crimes that basically said that they thought there was no intention to commit a war crime. And anyway, if the investigation takes place, I have no information that it has in fact started, but I would assume that this incident will be investigated and could be part of eventual prosecution, provided that additional evidence is found. But of course, is a huge challenge that the ICC will have in this case, like in other cases, is the difficulty in conducting investigations on the ground or even in surrounding states. It's unlikely that there will be a lot of state cooperation on this one. I will not go into the whole hostility debate, U.S. ICC, but and certainly not into the executive order, since we still don't know what's going to happen with that with the new administration. But nonetheless, even with a more sympathetic administration, the investigation of that situation will be extremely challenging, maybe even impossible. This being said, another essential aspect of this issue is the principle of complementarity, which of course means that the ICC is, or should be, the jurisdiction of last resort. When an investigation is open pursuant to Article 15 of the statute, like it's the case in the Afghanistan situation, the prosecutor must then inform all states who would normally exercise jurisdiction over the crimes concerned. In the case of the Afghanistan investigation, this was done just a few days after the appeals chamber decision. And a month later, mid-April of this year, Afghanistan, in fact, informed the OTP that it intended to investigate and to possibly prosecute the crimes allegedly committed on its territory. Unfortunately, there is nothing else in the public court records of the courts at this stage, so it's not possible to know whether this will actually be seen or considered as being a genuine process and could suspend ICC investigation. It's too early to know. They were supposed to file something at the latest on the 12th of June, and there's nothing public. So I think maybe the court is being very cautious as to what it lets out on the public record, especially in that situation, considering the situation it faces. Now, some people could say that this issue of jurisdiction is hampering the process of ensuring accountability for civilian casualties. And in a way it is, but I would also argue that it is a good thing that the ICC is this court of last resort, because it puts the primary responsibility on states, which is where it should be. Pushed to its ideal, complementarity should mean that the ICC is no longer necessary. Of course, we're still very far from that. But ideally, this is what we should see. We should see states getting a lot more involved in investigating and prosecuting crimes affecting civilians. But some states don't want to. Some states don't have the means to. It's a bit of a mixed bag, and that's why the ICC is still in operation and will likely be, unless something happens. In cases where jurisdiction of an international court is not or no longer an issue, there are still other challenges to achieving accountability that are posed by the simple context of criminal proceedings. First of all, of course, there's the evidence. And we already mentioned the difficulty of gathering this evidence, but there is also, in the case of criminal proceedings, proving the authenticity, the probative value, the relevance. Evidence of criminal intent may prove particularly difficult to obtain, and it seems that this was highlighted in the Kunduz case in the OTP filing. Now, linking the evidence to the correct perpetrator, the accused, is also complicated through the chosen mode of responsibility. And it's sometimes a lot more difficult than it seems, especially if you want to go and target higher up defendants. Linkage is an issue, and that's why the investigation is so crucial. And yet the ICC has so limited means, limited resources to achieve, or to get the very precise evidence that it needs to prove its case to the requisite standard. And now the assessment of the evidence may also prove difficult. And I would refer, for example, to the case of Gotovina before the ICTY. And I believe Professor Korn was an expert witness on that case, so you can correct me if necessary. But this case hinged on the issue of lawfulness of a series of attacks within Operation Storm, which was an operation launched by Croatian military to regain territory lost to the Serbs, and which resulted in the forcible displacement of Serbian population. Now, the evidence in this case was very technical and very difficult to understand for civilian judges and civilian staff of the court. Very few people within international tribunals have a military background to understand the weapons and how this works and the effect of the wind and how exactly this happens in reality. So the trial chamber, I guess, did its best, and it famously ruled that that artillery projectiles which impacted within 200 meters of a legitimate target was deliberately fired at that target. Conversely, it found that all impact sites located more than 200 meters from a target it deemed legitimate served as evidence of an unlawful artillery attack. Now, this seemed, and I think it is, a completely arbitrary measure. And indeed, the appeals chamber noted the trial chamber never explained how it got to this number, to this 200 meters criteria. And then it proceeded to overturn the whole judgment and the conviction of the accused in this case based on that. So this result might have been correct legally. It was nonetheless extremely controversial in the region. And while the appeals chamber, again, was mostly right, it remains that the Serbian population who were displaced may not feel like they've obtained justice in this case. Now, this is not to say that acquittals mean that justice cannot be done. I'm a defense counsel. I'm very adamant that acquittals can also mean that justice has been done, and we need to remember ourselves that accountability can also be achieved through other means, and justice can be achieved with acquittals. But in conclusion, I'd like to finish by saying that while international tribunals can achieve accountability and have done so for civilian casualties, their action is severely hampered. It almost takes place many years after the fact. It is very remote from victims, and it's extremely costly. In many respects, it is far less desirable than domestic prosecution or investigation or other mechanisms. This being said, I truly believe that it is absolutely essential that it remains in place and that actually it is strengthened. State cooperation is a big challenge, similar to what Olympia was saying. The ICC is struggling to get state cooperation. Defendants are struggling to get state cooperation that they also need to ensure their defense in a fair trial. So a lot of challenges, a lot of issues, but at the same time so essential, ever more so than before. And I truly believe that. We should invest more and believe more in this system, because for the time being anyway, it is one of the last hope for a lot of population victims who have been wronged and for whom there is no attainable mechanism to obtain justice. Thank you. Your microphone.
Thank you. I wish we had more time because, yes, I was involved in the Gotovina trial. I also led a group of experts that reviewed the U.S. military's investigation of the Kunduz bombing on behalf of MSF. And I remember spending about 10 hours on a Saturday in Brussels briefing them on the entire incident. I think one of the things you bring up in both of the presentations fits perfectly with where we're going, because it really highlights what is in many cases the very difficult translation of IHL regulatory norms into ICL principles. When you take an incident and you have to deal with issues such as a burden of proof, reasonable doubt, evidence-based judgments, there are many cases where you would come out concluding from an operational perspective that there might have been an error or there was an error, but the evidence is simply unavailable or insufficient to meet that evidentiary burden. And I think the Gotovina case is a good example of how challenging that becomes for a tribunal. So with that, I want to turn it over to my friend and colleague, Lieutenant Colonel John Cherry, who's going to give a little bit of perspective of some of the challenges of enhancing or ensuring accountability for for harm to civilians at the operational and strategic levels from the military perspective. Lieutenant Colonel Cherry is a deputy chair and military professor at the Stockton Center for International Law at the U.S. Naval War College in Newport, Rhode Island. He has served in a variety of assignments, including deputy legal counsel, office of the chairman of the Joint Chiefs of Staff, staff judge advocate for the 2nd Marine Logistics Group, an assistant professor of international and operational law, and vice chair of that department at the Army's Judge Advocate General's Legal Center and School in Charlottesville, Virginia. In 2004, he deployed to Guantanamo Bay, Cuba, serving as the forward legal advisor for the Combatant Status Review Tribunals. In 2010, he deployed again to Delaram, Afghanistan as the staff judge advocate for the 2nd Marine Regiment Regimental Combat Team 2. In addition to his duties with the Stockton Center, Lieutenant Colonel Cherry is the president of the U.S. Group of the International Society of Military Law and the Law of War. He's also one of the nicest and most thoughtful officers I've ever encountered in my 35 years of being associated with the military, and I'm delighted to turn the floor over to you, John.
Well, Jeff, thank you very much. I really appreciate that. And of course, I throw the compliment right back to you. You've caught me a bit off guard now. I'm a bit flustered, and it's not often an Army guy flusters a Marine, but we'll go with it. Thank you very much, to the organizers of this event. I can assure you that the Naval War College and the Stockton Center are honored to be co-sponsors. And when you look at the email we all got, advertising this event, and it talked about, approaches that are preferable, feasible, and likely to promote IHL LOAC compliance. And that last part, likely to promote IHL and LOAC compliance. And I would suggest that if we have to ask that question, which approaches to the law can help our commanders ensure that they comply, I think we're lost. Our commanders and troops comply with the law of armed conflict because it's their duty. It's because of their education. It's part of their evolution as a Marine, a soldier, a sailor, in the United States and in governments across the world. And of course, as a leader in and out of combat, we want them to comply with the law because the principles of distinction, proportionality, military necessity, humanity, precautions have been drilled into their heads from the first day wearing the uniform until the day they retire. And most importantly, because it's their obligation. It's an obligation as a member of the military, and of course, it's the right thing to do. That obligation can create a heavy burden for our commanders, a burden that they readily accept. In my comments today, I'd like to frame the military's view of the commander and the expectations and demands organic to command. And of course, also the related expectations and demands we place on our troops on the ground and how that contributes to accountability. When we have discussions about CivCast accountability, I, for one, and many of my colleagues often hear the question, why don't we see more prosecutions? If the United States government and other governments profess to have various forms of accountability, where are the prosecutions? We see reports in the press about strikes that cause civilian casualties. Where's the accountability for those strikes? And I think at times that's a fair question. And also, to be fair, it's not always an easy answer. Civilian casualty events, regardless if they're committed by a government or by insurgent forces, are often very public and always tragic. But the ensuing investigation that follows and the related administrative or criminal remedies, that accountability we look for, are typically not equally public. Oftentimes for good reasons. Classification purposes or other requirements regulate that transparency. In conversations with many of you who I know are on the Zoom today, inside the Pentagon, within the interagency, with congressional staff, transparency is a common theme. And you also heard Olympia talk about access. Access is a common theme as well. Access to the U.S. government and other governments in some form to report these CivCast incidents. One example of our efforts to do that, you can see the Undersecretary of Defense for Policy has a reporting civilian casualties website. That's an example of how we can continue to provide that access to those outside the U.S. government. Now, when we discuss accountability mechanisms, it's very important that to remember that we can prosecute. We can prosecute war crimes. We can prosecute LOAC violations. We can prosecute bad judgment. We can prosecute lack of supervision. In fact, we can prosecute having knowledge of events, and we can even prosecute what the commander should have known about potential events. Now, that may seem harsh, but the requirement of the commander of the military is to know everything that is happening in their unit and to lead that unit in combat operations within the confines of the law and policy. You know, as they say, heavy the head that wears the crown. And with great responsibility comes a serious level of accountability. And the doctrine of command responsibility, in fact, allows us to impose liability on a commander for acts of their subordinates. You know, so not just what the commander, him or herself, commits, but acts of those in their units that fall under their command. And this relationship between, you know, responsibility and accountability between the commander and her staff, you know, at the highest levels between the Department of Defense and individual services, is a relationship that is built on trust. And for our accountability mechanisms to work, we must trust our commanders to understand the battlefield, the enemy, weapons capabilities, you know, the strength and weaknesses of their subordinate units and the men and women whom they lead in combat. You know, of course, understand the rules of engagement and those tactical directives that are based in law and policy and our operational goals. And of course, certainly not least, the laws of armed conflict. You know, we need our commanders, particularly when it comes to civilian casualties, to understand the law, but also operationalize it and include that in military planning processes, you know, to have the knowledge and the information and the foresight to hopefully avoid civilian casualty as much as possible. And, you know, obviously, I've worked with commanders for years in combat and outside, and commanders not just from the US, but from many of our allied and partner nations. And I'll tell you, from my experience, more than ever, commanders today understand and appreciate their obligations under the law. And they truly have a keen interest in getting it right. They understand the importance of an efficient, effective, and truly humane approach to combat operations. But obviously, we wouldn't be here today if the military didn't sometimes get it wrong. You know, at the mission execution level, at the investigative levels, you know, and of course at the accountability stage. And when civilian casualties do occur, and it oftentimes leads to profound and tragic results for the civilian population, and when that happens, the U.S. government requires that every potential CivCas event is reviewed. And that can occur through, you know, commander preliminary inquiry, which is more of a efficient and lower level way to review an incident, or through a detailed and lengthy command investigation headed by a general or flag officer, you know, the investigations that you heard both Marie Helene and Jeff talk about earlier today. You know, how do you choose, right? Which ones you, and of course, I'm going to give you a typical lawyer answer. It depends. It depends on the facts the commander has at the time he or she became aware of the potential for the civilian casualties. You know, and if the facts end up supporting wrongdoing, whether through commission or omission, that of course then lends to another decision by a commander who would be in command of the person or the unit involved in the incident. Again, another lawyer answer, you know, depending on the facts, the individuals may be subject to criminal prosecution or administrative processes or both. You know, the court-martial process can, you know, come with some serious penalties: fines, loss of pay, reduction in rank, incarceration, discharge or dismissal from the service. And so, okay, well, where are these prosecutions? Where's the jail time? Where's the dismissal? Again, we see this news in the press. Where do we see these remedies? Where do we see this accountability? It's important to remember that LOAC and IHL have a strict parameter for holding commanders accountable. And I think you heard, you know, Olympia and Marie Helene both talk about that, you know, kind of the gap between the facts, the law, and the ability to hold the perpetrators accountable, you know, because those parameters within the law require knowledge, you know, intent or recklessness. And that form of accountability, you know, if it doesn't exist, then we can look to the administrative processes. And the administrative processes don't always require those same standards of knowledge, intent, recklessness to hold commanders accountable. LOAC doesn't necessarily hold someone accountable for being a bad leader in combat, but the United States government does, and other governments around the world do. And that's exactly where these administrative actions come into play. In the wake of the Kunduz strike, former Secretary of Defense Ash Carter issued a memo. For our purposes, a memo is also a direct order, and for a comprehensive reform and reviews of everything that went into the Kunduz strike, and to include systems interoperability with our partners' forces. Now, of course, that memo doesn't bring back the lives lost in Kunduz. Nothing can do that. But it does help to prevent a similar tragedy from happening again. That's very important to understand, right? That's the point. This is the reasons why the governments around the world are working on these processes, on advanced technology for weapon systems, on directives and policies and lessons learned, and why we train our men and women to do their jobs while always being aware of the law. The point is so these incidents don't happen again, so we don't have a repeat of Kunduz. But when they do occur, our citizens must understand, our military, our governments must understand that the US government and governments around the world have accountability processes in place to quickly and effectively address those incidents. So in the interest of time, we'll send it back to Jeff. Thanks again so much for this opportunity.
Thank you, John. So with the amazing presentations we had, we only have a few minutes for questions. I'm going to use my prerogative as the moderator. I want to ask John one, and then I want to ask one to the group collectively. John, tomorrow I'm speaking at the JAG School presenting an article that Rachel Van Landingham and I just finished, arguing that it's time to incorporate an enumeration of war crimes into the UCMJ punitive articles. Why have we enumerated war crimes for our enemy at Guantanamo, but we still rely on this practice of alleging common law derived offenses to prosecute war crimes? Olympia made the point that one of the functions of war crimes accountability is the symbolism. So I understand that if you charge and convict somebody for murder, that's a very serious conviction and it's going to carry a very serious penalty. But the perception of legitimacy, I think, is undermined by the fact that our commanders don't have the option of actually alleging a war crime that's been enumerated in the code. I'm just curious what you think about that.
Yeah, that's a great question, Jeff. And obviously it's one that's been asked for a long time. And I honestly agree with you. It doesn't make sense, right? We have to find an analogous crime, in our own in UCFJ to charge war crimes. Now we can do that, and often that war crime involves murder, and so there's obviously an analogous crime. But we have so many other enumerated crimes that don't exist in the civilian world with which we can hold our commanders accountable for those lacks of judgment and things like that don't involve an actual war crime. And so I think it stands to reason that it would, if for nothing else, make the process easier for the prosecutors and for the commanders to actually have those enumerated war crimes.
Yeah, it doesn't have to be binary, right? The commander would have the convening authority would have the option of even mixing them. I also think it might be beneficial because if we wanted to prosecute a captive for a war crime, it would enhance the likelihood of using the general court-martial in lieu of creating a new tribunal because the crimes would be enumerated in the code. Olympia, you brought up the point about the challenge of evidence collection and when you're dealing with an extraterritorial crime. Maybe I was thinking along the lines of Marie-Helene as a former defense counsel. That seems to me to be even more problematic. If the defendant needs exculpatory information and that exculpatory information is held by the state and the state is objecting to the assertion of jurisdiction, there's just no way that state is going to cooperate with the defense counsel to give access to information. Would you agree?
Absolutely, I would definitely agree. And I can see Marie-Helene nodding to that. Many times in practice, the defense lawyers don't even get the chance to go and visit the country and interview, and they don't have the means even. They don't have the team, the finances, even if that option is there, on behalf of the government wanted to cooperate. So it's not that easy. But again, I think Marie-Helene could fill us in since that's her bread and butter, really.
You want to comment, Marie-Helene?
Just very briefly, yes, it's a huge challenge. Being part of defense teams at the ICC, first of all, when you start as a defense team, you're already years late on the prosecution. So you have a incredible amount of material to already review. They're supposed to investigate both exonerating and incriminatory evidence. Sometimes we doubt that there's a lot of effort done on actually gathering exculpatory evidence. So defense investigations are crucial. And yet, indeed, a lot of the time when a state refers its own situation to the ICC, it's because it's on the side of the prosecution, right? So as defense, we can send letters, we can send requests for cooperation. A lot of the time they remain unanswered. We hit a wall in terms of investigation, and that has a big impact on the fairness of the proceedings.
So we're almost out of time. I have one more question for the entire group, including Beth. By the way, Beth, thanks for answering the online question from Andrea. Are we too focused on result crimes? Should we be more focused on conduct offenses? You know, John mentioned the principles that commanders are taught to embrace, and I'm glad he included in that the principle of precautionary measures, because he knows that that's been an area that I've been very vocal about, especially after my experience with Godovina, that if we really want to judge the quality of leadership in combat, we should be focusing more on the efforts to mitigate the risk to the civilian population through the precautions principle. But when we think about accountability for civilian harm, we almost always instinctively gravitate towards result crimes. When in fact, what that does, in my view, is it gives a pass to commanders on the battlefield who are indiscriminate in their practice and lucky in their outcomes because they don't produce the harm. And the fact that a precautions violation is not an offense in the ICC elements of crimes seems ironic to me when someone like John would say that's probably one of the most important rules that he's advising his commanders to embrace. Just some final thoughts on that. Anybody? John?
I'll defer to everyone else since I already made my views known on that.
Beth?
Well, the only thing I was going to say is that one crime that is not listed within the ICC statute, which I think was a real mistake, is the crime of causing terror in the civilian population, which, as you note, is not a results crime. We know that from the Galich case coming out of the ICTY. It's enough to unleash a sort of course of conduct, the primary purpose of which is to terrorize the civilian population. I would like to see that more available to prosecutors, because you don't need a victim necessarily to come forward and show harm. And
Right.
as we know from the previous presentations, how difficult that can be. This you can show that just by evaluating the very nature of the operation was sufficient to satisfy the elements of that particular crime.
Yeah, you know, the other thing I've started to work on along similar lines is the need to pay more attention to the attempt version of the crimes. It's
Exactly.
interesting that attempt is a recognized offense in the statute.
Yeah,
And
it's under prosecuted though.
It might enable more focus on pernicious conduct that doesn't produce the pernicious result. Well, we're over time by 1 minute, so I'm going to thank all of the panelists. It was really a pleasure to meet people I didn't know. It's always a pleasure to see Beth and John. And I wish everybody a good day and limited Zoom time for the rest of the week.
Thanks, Jeff.
Bye-bye.
Thanks, everyone. Take care.
Have a great day.
Bye.